My husband can't, you know, should try.
Yeah.
Try, but it's not gonna work out.
Well, my daughter-in-law just, well, my youngest grandson is a year and a half now. It's, I don't know how long, I say she gave up nursing.
Oh, yeah.
Every once in a while, she gets the bangs
Yeah.
for, you know,
That's
usually she was saying,
Every woman has a different journey. They tell you, well, some women are like, in it for the long haul. I am for my children getting the best that they can get and then being as independent as they can be when it is the time.
yes,
And believing in them and knowing I set them up for success.
right.
I love my baby with all my heart, but it's a lot to balance. It's like part-time job on top of just the normal life and work and caring for all the 4 kids. So.
That's an understatement. You're saying it's COVID.
Yeah, my best friend has 4 daughters and she nursed her last one until 3 years old. And that, no, you are, that's, that is, you know, it's like, hey, no. Good for you guys and I don't.
You get to that
Yeah.
refrigerator right now.
Right. I'm gonna talk and that's, and then it goes on for me.
What?
Make it?
Oh, the game?
Yeah.
Oh, yeah, they lost by 1.
Ooh.
I was worried. I pulled down onto the highway and I was like, oh no. But this is really bad. Ernie's not gonna make it.
No, we got there.
All right, there we go.
We were there right, like, with 15 minutes to go, so we really got to warm up.
Oh, that's enough warm up time.
You play well?
He's had better days.
There's a good one. Yeah. There's a good one. What does he play anyway? I don't think that question's ever asked.
He pitches and mainly he did pitch last night.
Yeah, long time no see.
Base.
They have a 3-inning limit still. I mean, obviously, yeah.
Big
What's
league
that?
does.
No.
This league doesn't.
Fish limit or anything next to it?
This one doesn't, it's kind of, it's a fall, like, rec league for fun.
Okay.
So it's kind of coaches honor to make sure.
Okay.
And most of them are letting, you know, can't pitch the one, which is like a play. Yeah, it's we pitched last time. My son is 13. Thanks for asking. All you guys, so.
I was worried about you. I really was. I was like.
So be free to slam the door anytime. When you weren't around when I walked out that same, it was like, it was actually the same. It closed and I was slamming the door.
The times I got out there, all the traffic, I'm living happening.
Yeah, all
But like at a certain point, it broke up and then it's just a matter of speed. A lot.
Yeah.
Colors.
I don't mind
Oh,
that.
can I-
Yeah, you know.
I mean, it's really not fun.
Thank you.
I normally have one of my supermarket bags.
Oh,
Did I get it down, Stephen?
Yes, sir.
All right,
Yes,
thanks.
sir. I'll never forget. I had my picture taken. It's been a long time ago and, you know, I was excited about it. Came back and my collar was up like this. I'm like, where did you get this? I say something.
That's their job.
Yes.
Especially if they want you to buy the pictures, you would think it's in their interest.
It is, these are, there's, for a power strip, you might be able to reach.
Yeah.
Right, well, this,
I just figured.
this, you can pull this a little bit, Chris.
Oh, I
You
just-
don't so much.
Oh, so that shouldn't.
That should be funny.
No, yeah. That's right.
Yeah,
not saying into it.
I think that'll reach you too. Yes. Perfect.
but that was, thank you.
Oh, absolutely. I just figure I hate to have you sit over there charging.
I need to choose to.
Yesterday, she chose my life. Oh,
Yeah.
same application.
In this building, even the snow, you feel it? Or
Feel
is it
what?
just like stuffy, heavy, like very
Yes,
warm?
I do.
Okay.
Yeah, it feels humid.
You know, like, of course, I walk a couple of blocks, and, you know, like, I'm a little warm, but it just feels really.
You had a big day yesterday, too.
But that's not this morning. It's very fun this morning.
Yeah. Yeah, it's just in between that
That's fair.
hot and cold
That's fair.
season. I think your body is acclimating.
It's that,
I can relate wholeheartedly to when they get under control over how long they're going.
it's that, season where, you know, you put away your summer suits and all of that, but then you need them. You know, it's like, it's almost what we call sweater weather.
It's something.
It's not that-
Yeah.
I'm a big fan of sweater weather.
Yeah.
Excellent.
I'm in search of endless summer, so I.
Oh, you and I talked about this, I think. Are you a beach bum? Okay,
I
okay,
just got back
okay, of course you.
and already I'm planning the next time I can go.
Are you in the 30A again? Rosemary?
Well, our place is in Panama City Beach, but we can have a lot like seaside area. Oh, yeah. Beautiful.
Like, say it's right right now, she was probably slowing down a bit, or no,
It's not
maybe
too bad.
more fall.
Oh, it's not bad. It's really, I mean, it's just perfect, honestly. All right, so it's 10:08. I'd like to call the September 28th, 2023 meeting of the Ohio Elections Commission to order. Mr. Richter, will you call the roll, please?
Mr. Carroll, Mr. Lyle. Present. Ms. Hagan.
President.
Mr. Knight.
Here.
Mr. Foley, present. Vice Chair Lars.
Here.
Chair Hawkins.
Here.
All members are present.
I don't think we have any minutes to review.
We do not have any minutes. Bill got lazy. I thought about actually trying to minutes last night and didn't do so. Probably could have gotten them done too, so I apologize. I will have them ready for the next meeting. We'll have a couple of minutes to go over.
We don't need to read. So, okay, so the first up on our agenda is a preliminary review. It's case number 2023D-012, and I believe everyone here.
There is no one here for that. This matter. Madam Chair, members of the commission, this is a disclaimer complaint with complaint asserts that the respondent did not include a proper disclaimer on certain campaign materials. The respondent submitted a response explaining that there was an initial failure, was a simple oversight, had been corrected. He included a copy of the postcard that was an issue, showed that he put a stamp on there. And additionally, the respondent included a picture of other campaign materials on which there is a disclaimer. And so my recommendation under this set of circumstances is to find a violation but for good cause, not oppose the fine, or refer the matter for the prosecution. And I'll be glad to answer any other questions that the commission may have.
Any questions of commissioners?
I'll make the recommendation as a second if there are.
Okay, we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye. Press same sign. Motion carried with a vote of 7-0. The next item is case number 2023G-014.
Yeah, this, Madam Chair, members of the commission, this is a self-referral from the candidate. Finds himself out of balance. Funds were dispersed in an attempt to terminate, but somehow it was submitted. The committee subsequently reflected a negative balance of approximately $2,500. And it still desires to terminate. I request the commission allow the commission to terminate. My recommendation is to find a violation, impose $100 fine, really because the committee is incredibly out of balance, but to then declare that the committee is terminated. I'll be glad to answer any questions that the commission may have.
Madam Chair, question for the executive director. So in reading this material, the campaign committee had $5,355.20 balance, if I'm reading correctly. Candidate divided that the 300 and change to different nonprofits. I don't understand how it could have had a negative. Is this a separate checking account? I mean, is there a bounce check somewhere at a bank of negative 2539.74?
Good questions that I don't know that I can otherwise answer based on, what was submitted here. It does seem odd, let's say, but, whether, you know, it sounds like there's just an incredible accounting here in the campaign finance report, I guess is the assertion that I would claim if I were them, or that I'm relying on as I read their materials.
So on the materials that we have, is the letter or the affidavit that is a self-referral.
That is correct.
Did the self-referral include any documents?
No, you have what I received.
Okay. My concern, if I may, Madam Chair, my concern is I appreciate the self-referral. But it doesn't necessarily, that what's in the referral is not necessarily backed up by, there's no proof. So you have a negative balance of 2539.74. In fact, was the 5355 dispersed to two different nonprofit organizations? I guess this document leaves me more confused. We're seeking more answers. So I just wanted to put that out there.
Sure. But I mean, it is in an affidavit of complaint, you know, where they are attesting that, you know, it is a notarized statement where they're attesting that the circumstances that they are explaining are true, show the factual circumstances. And so, you know, that's a reliance on which we depend. I depend on making these kind of recommendations and so relying on them to speak truthfully. So,
Thank you.
Any other questions or comments? Hearing none, do we have a motion?
I'll move the executive director's recommendation. Second.
We have a motion on the floor that's been duly seconded. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carries with a vote of 7-0. The next case we will take out of order from what you see on your agenda. It will be preliminary review. It's case number 2023R-067, and I believe. Mr. Rice.
Madam Chair, members of the commission.
One of the notes.
This is a referral from the Cuyahoga County Board of Elections against Chantel Brown and the Friends of Chantel Brown. From when she was a city council person in the city of Cleveland. There was at the time, it was a failure to file the 2022 annual report. Subsequently, the report was filed in March. A response was submitted by the treasurer, which, you know, you have it all in front of you, my synopsis. I don't think I included any of these materials in advance to all of you. Mr. McTighe, who is here on behalf of Ms. Brown, excuse me, we can hear from him in a second. He submitted these materials to us late last week, I think it was, and then asked that this matter be placed on today's agenda since he was coming over here. And so, out of courtesy to him, I did so. And so the explanation goes through the thought process of the treasurer, what they were doing, et cetera. The fact that this is a state candidate or a local candidate committee, separate and distinct from the federal committee that Ms. Brown now has in her congressional seat. My recommendation, based on the facts and circumstances and the explanation, is to find a violation and impose a $50 fine. Certainly, if the commission would like to hear further from Mr. McTighe, his client's behalf, we can do so.
Good morning. Yes, I'm Don McTighe on behalf of the respondents, Friends of Chantel Brown and Chantel Brown. As you've already been told, Ms. Brown is currently a congresswoman, but before that, she was a member of not the city council, but the county council. Cuyahoga County has a charter form of government with a county council. And her treasurer of her state or county committee forgot to file an annual report. They still had a balance and eventually filed it in March rather than January. And there was a communication at that time between the treasurer, and Rosemarie Amato, who is, numero uno on campaign finance in Cuyahoga County. And the treasurer unfortunately misinterpreted a statement that no more reports would be required because they were going to be terminating. What Ms. Amato meant was they didn't have to. Ms. Amato allowed the treasurer to amend that the 2021 report that was late, but of course, because they didn't terminate right then, they did have a 2022 annual report due. That was, again, that was filed late, a couple months late. And it was filed as subsequently a termination report was filed, and the entire balance, which was $22,882.50, was donated to College Now, which is a 501c3 scholarship fund for students of Cleveland Public Schools. So based on that, there's clearly a violation, but I would request that no fine be imposed due to the misunderstanding here and the fact that all of the proceeds down to remaining 50 cents has been donated to charity. Thank you.
Thank you. Any questions on commissioners?
I have one for executive director, since we don't have the materials. Does Ms. Brown have any priors?
Yeah, if you look at the outline there's a prior, but it was back in 2012.
I'm sorry.
It was back in 2012. And
So that was in 12 though.
yeah, it 11 years ago, and you can cause that case, obviously, but that one was for initially, at least, figure file decimation charge. There were no other cases involving this round at this point, aside from this.
And for the new commission members, I'm not sure they're aware of it, and correct me if I'm wrong, but typically if they're not within 5 years, even though we see them, we don't really look to them for like progression, right?
Correct, especially in a case like this where it was good cause at that point. I mean, if there was a while ago where it was an outstanding fine or something like that, that would be taken into consideration. But beyond that, no, I mean, it's a notation on the on the outline just to show that there was something, because it is a part of our records. But it really didn't factor into what I recommended. The primary basis for my recommendation here is the difference between January 31 due date and the March 20 budget date. So if the commission wants to go in a way, I would certainly understand it.
Well, based on Mr. McTigg's explanation with Ms. Amato, I think I would move that we find a violation, but no fine.
I'll second it.
Okay, you have a motion on the floor that's been duly seconded. All in favor, signify by saying aye. Opposed, same sign. Motion carried to the vote of 7-0. Thank you.
Thank you.
Okay. So, next item is a preliminary review. It is in case number 2021G-020. Do we have
Yeah, Madam Chair, members of the commission, seen this one before. Preliminary review. Where the commission made this determination to set this for hearing. There was a request to reconsider that because Mr. McBride, was not properly notified. Let's try that. And so at the commission's last review of the matter, the commission found good cause to reconsider the matter, bring it back before the commission for preliminary review. Here we are back again today. Certainly, we can hear from the parties. Mr. McTighe represents the complainant. Mr. Bride represents the respondent. I see you standing up, but I guess we would hear from Don first.
Oh, I thought you were going to hear my motion first.
Huh?
I thought you were going to hear my motion to dismiss first.
Oh, the one you filed 2 days ago?
No, the one I filed 2 years ago. I filed a reply brief in support of it last 2 weeks ago.
Oh. Okay, yeah, okay,
Madam Chair, whatever you tell me to do.
doesn't matter.
Doesn't matter to me.
Okay, please then go ahead as it relates to your motion. Yes.
Thank you. We filed in, I think February 2022, a motion to dismiss. And it was heard, as the commission knows, without us receiving notice. And obviously, it's hard to, Don McTighe is an effective advocate. But he's more effective when nobody's there to present the other side. And I'm probably the same way. I'm not trying to pick on him. So because that would violate fundamental due process rights, it was reconsidered by unanimous vote of the commission. And therefore, I presume that nobody's going to rely upon what was done in an improper manner, because we're having to do over with a fresh start, and everybody's going to consider a fresh slate and not rely upon, well, we did this before without me being there, therefore we got to do it again, kind of thing. A couple things preliminarily. 2 days ago, on September 26th, One Worthington was certified as dead, as terminated, as canceled by the Secretary of State. Now, I've copied the Commissioner, Don McTighe, and I let opposing counsel know that this was in the works sometime before it happened, and it finally happened. I'm not quite sure why it didn't happen until 2 days ago, but it did. So for that reason alone, I think you can't put a corpse on trial. I understand that in 897, Pope Stephen put the corpse of his predecessor on trial for heresy, found him guilty, and threw him in the Tiber. But I would suggest that that wasn't the church's finest hour. This commission may not want to use that as a precedent. Secondly, there is another respondent, Christine Scott. But Christine Scott is not the treasurer of a PAC, because you don't become a treasurer of a PAC under Revised Code 35-1710D1 unless you file a form becoming the treasurer of a PAC. And she is not alleged to be a treasurer of PAC. She is an officer, or was an officer, of One Worthington when it was viable. And there are no statutes that are cited that say that she as an individual is liable for doing anything. Ms. McTighe has argued, well, she's an officer of the corporation, therefore she's kind of sort of like a treasurer. There's no kind of sort of in Title 35 of the Ohio Revised Code. You either are a treasurer or you're not. And if you're not, and she's not, you can't pretend that she's a treasurer and go forward against her for an office she never assumed or took. And then thirdly, and although I think these first two arguments are sufficient to grant the recommendation of your executive director, legal counsel, to dismiss the thing, I'd like to spend a little while talking about the reason why, even if One Worthington was still in operation, and even if 100% of its expenditures were for independent expenditures only, it would be illegal for this commission to say you could be a PAC in that circumstance. In other words, even if 100% of your activities are independent expenditure activities, it would be illegal to declare them a PAC. Citizens United created what we often refer to as super PACs, basically independent expenditure only entities. In other words, entities that all they do is independent expenditures advocating the election or defeat of benefited candidates. And there are differences between the form of what is commonly called super PAC and what is an Ohio PAC. There are differences in what they can do, and there are differences in what they can't do. For example, corporations can become Ohio PACs. Corporations cannot become Ohio PACs under the Revised Code. It says in 35-9903A1 that no corporation and no nonprofit corporation shall pay or use, offer, advise, consent, or agree to pay or use the corporation's money or property for an aid of or in opposition to a political action committee. So if you can't use your money to support a political action committee, you can't be a political action committee. That has long been the definition of Ohio. By the way, that's different in federal law. In federal law, corporations are allowed to incorporate. And this commission, back in 1996, had issued an advisory opinion, 96 ELC 12, where it talked about that, because the recently in the mid-90s, the General Assembly added nonprofit corporations
to the prohibitions in addition to for-profit corporations. And they said, well, what about corporations that under federal law, which allows corporations to be PACs? They want to do expenditures for state and local folks. And the advisory committee says for federal PACs, who for liability purposes have incorporated, you can still do contributions for state and local candidates in Ohio, because after all, the FEC's rules trump Ohio's rules. But it didn't change the rule about Ohio. In other words, nothing in that opinion stated or suggested or implied that in Ohio, the corporation that is a state and local non-federal PAC can be incorporated, because it can't. Secondly, PACs cannot accept corporate contributions, whereas super PACs, independent expenditure entities, can. You know, the Citizens United had accepted corporate contributions, and the United States Supreme Court said you have a constitutional right to do that, regardless of what the code of the United States said, regardless of what Ohio law says, frankly, although Ohio law wasn't directly implicated. And you know, so corporations can give to independent expenditure entities, and corporations can be independent expenditure entities, but corporations cannot give to Ohio PACs, and corporations cannot give, and by corporation I mean 1701 for-profit corporations, 1702 not-for-profit corporations, because this commission made a distinction between those types of corporations, LLCs, professional associations, limited liability partnerships, and it made that distinction again in 1996. In 96 ELC dash, I believe it's 02. Check. 03, 96 ELC 03. Basically, it said, for purposes of election law, a corporation is a for-profit or nonprofit corporation formed in accordance with 1701 or 1702 of the Ohio Revised Code chapters, and does not include what was then a relatively new concept of corporate and like entities, and a limited liability company, a limited liability partnership, a professional association. Those are treated as partnerships, which by definition are more than one person. So the argument, well, this commission decided an LLC was more than one person, has nothing to do with whether or not a corporation is more than one person or can be passed. Thirdly, PACs, Ohio PACs, are subject to contribution limits. There are limits for Ohio PACs on how much you can contribute to an Ohio PAC. They're set out in Revised Code 3517-102. There are no limits in the United States Supreme Court, and the DC Circuit in the Speech Now case stated there are no limits and can constitutionally not be any limits on how much you can contribute to an independent expenditure only PAC or independent expenditure only entity. You're not a PAC. PACs in Ohio law can coordinate with candidates. They can coordinate their expenditures with the candidates. Independent expenditure entities cannot do that. If they do that, they're breaking the law. And how do I know that? This commission has said if they do that, they're breaking the law, but the Ohio Revised Code said that too. You know, the PACs can donate to candidates. They can go donate directly to candidates. Independent expenditure entities can't do that. The cost of admission is you can't coordinate or you can't donate. You've got to make sure all of your activities, all of your expenditure are independent. And lastly, federal super PACs have reporting requirements. Federal independent expenditure entities have reporting requirements because federal law is different than Ohio state law. How do I know that? I know that because this commission told me that. And it told me that in its advisory opinion, 2010 ELC 02, when it said that it would apply the rules of Citizens United and its progeny to Ohio activities. And it also said, with respect to these independent expenditure entities, there is no specific obligation currently in Ohio law to file a statement that reflects their activities. We have no right to rely upon this, and we did rely on it. This commission has a duty to obey its own advisory opinions, because frankly, if this commission doesn't pay attention to its own advisory opinions, what good are they? Why should anybody pay any attention to them? And this commission has stated that there is no obligation for an independent expenditure entity to report anything. Now, Citizens United was decided in January 2010 by the United States Supreme Court. And it declared a constitutional right of corporations to make independent expenditures without becoming political action committees. The idea of why can't they just become political action committees is addressed in that opinion. And the United States Supreme Court said you can't require them to become independent expenditure entities. Now, opposing counsel has made the argument, well, what if in his briefs, well, what if most of what you do does not make a difference? If your primary activity is influencing through independent expenditures, does that make a difference as to whether or not all these requirements of campaign, it limits on how much you can receive and who can receive them, as well as the reporting issues of PACs, can't they be applied to? And 2 months later, in March 2010, on en banc, all 7 judges of the DC Circuit Court of Appeals, including 2 judges that later became members of the United States Supreme Court, one a conservative, one a liberal, Ginsburg and Kavanaugh, I believe, unanimously said for Speech Now, which was an unincorporated association, clearly 2 or more people, that spent 100% of its activity on independent expenditure. So there's no question about whether it blew past that threshold. Could not be required to abide by all of the restrictions of a PAC. Yes, it could be required, is under federal law, to file reports of independent expenditures, because federal law requires that. Ohio law does not. We'll get to that in a moment. But it could not be determined to be a PAC for all purposes. For example, it could not be prohibited from the source of contributions, the amount of contributions, and other activities that apply to PACs in Ohio, but don't apply and cannot constitutionally apply. So when you're trying to declare an independent expenditure in Ohio PAC, you're trying to fit a square peg into a round hole. Well, the question is, what if federal law allows and requires independent expenditure reporting? Why can't Ohio law do that too? And the answer is Ohio law could do that constitutionally, but it has not done that. How do I know that? I know that not just because this commission told me that. Why did this commission tell me that? This commission told me that because Revised Code 35-17-105 is the statute which talks about reporting independent expenditures. That's where you find out what needs to be reported as an independent expenditure. And there are various requirements of even of corporations to report certain independent expenditures, but with respect to corporations, you only have to report independent expenditures with respect to issue campaigns. And there's nothing in Revised Code 35-17-105 which requires the reporting of independent expenditures with respect to candidates, which is all that Lon Worthington was doing. So if we were here talking about, well, they were influencing a levy campaign, well, they got a duty under Ohio law to report that. They weren't. That's not what we're talking about. We're talking about influencing candidates, and the General Assembly could have decided to add that to this statute, but they didn't do it, and they haven't done it since 2010, when this Ohio Election Commission issued an opinion saying there's no duty of corporations, and it didn't qualify the types of corporations. Other than 1701, 1702, didn't qualify by saying only corporations that don't spend over a threshold, or only corporations that do a minority of what they do. It said no, any corporation that engages in the activity constitutionally permitted by the Citizens United's progeny, doesn't have to follow the Ohio laws that are inconsistent with that. And you also said, this commission also said, maybe not you as individuals, but this commission also said they have no reporting requirement. So right now, we're being asked to have a hearing on whether or not doing what this commission said we have a right to do was illegal if we did too much of it. And we're asked to have a hearing on a factual issue, where this doesn't revolve on a factual. Yes, it would if there were an issue about, I think he's wrong, and about how much was done. Was it substantial? Was it most of what they did or not? But I understand that's a factual dispute. And here I'm to talk about the illegal facts, which are not and cannot be disputed. And by the way, that is why I realize some of you are lawyers, some of you are not. That's why you have a legal counsel. You've got a legal counsel to keep you out of trouble. You've got a legal counsel to keep someone I'm not making any threats, but I always understood that you don't show true honor for your mother by failing to warn her off a cliff until she's fallen over. If you want to change your advisory opinion, you have jurisdiction to do that. You don't change an advisory opinion by holding an evidentiary hearing on somebody who's relied upon your prior advisory opinion. And by the way, if you did change your advisory opinion and said, we're going to declare independent expenditure entities that have most of what they do, independent expenditures, I believe you would be violating 42 USC 1983, and you would get in trouble for that. You'd probably get sued. I'm not going to threaten to sue you, but you've been sued plenty of times by people other than me. I don't think I've ever sued the Ohio Elections Commission. And I'd like to keep that streak going, but I can predict, and you can predict too, because you've seen it happen. And there's a long history, even before the Ohio Elections Commission, Socialist Workers' Parties versus Brown, when they were trying to make people who were going to be subject to harassment for disclosing their identities. The U.S. Supreme Court said they couldn't do that. The McIntyre case, where the Ohio Elections Commission was sued because they wanted an individual to file stuff and reveal stuff, and they didn't have to. They could even use a fictitious name. The Susan B. Anthony cases, we're all familiar with that, which dealt with ultimately the false statement issues and things. So I'm saying that this happens on a fairly regular basis, and I would respectfully suggest it's not in the interest of the commission to make it happen again. But that's down the road. If you decide you want to change your advisory opinion, knock yourself out, but you haven't changed it yet. We relied upon it. We had a right to rely upon it. So those are my three arguments why the legal advice of your lawyer should be accepted and followed. One, Worthington is dead and you can't try a corpse. Two, Christine Scott is not a treasurer. And just because she's kind of sort of an officer of the corporation doesn't make her a person who was filed on a piece of paper that was never filed with the Secretary of State's office. And three, One Worthington as an independent expenditure entity cannot be an Ohio political action committee, even though if the legislatures chose to, they could require additional reporting from them as the federal authorities following federal law, which is different than Ohio state law. Thank you.
Good morning. I'm Don McTighe on behalf of the complainant. I'll address the legal arguments raised by Mr. Rye. The first, he suggests that the case with regard to the corporation is moot because they have filed a cancellation or dissolution with the Secretary of State. It's a nonprofit corporation, and revised code section 1702.49, which is titled Winding Up Powers and Duties of Directors of Nonprofit Corporations. Paragraph or division B says any claim existing or action or proceeding pending by or against the corporation or that would have accrued against it may be prosecuted to judgment with the right of appeal as in other cases. So state law provides that you can't, if you're a corporation, you just can't disappear. There is, if the claim has accrued before that, before the dissolution, the claim can be prosecuted further. So that takes care of that. With regard to Christine Scott, I think the argument there was that she should be dismissed on the basis that she's not a PAC treasurer. However, the commission's rules on complaints require that or allow for the naming of a responsible person. That's the language used in the commission's rule on initiating proceedings. Ms. Scott is identified on the corporation's 990, which is something that nonprofits have to file with the IRS and is public information. She is identified as the I'll get the exact language here, the principal officer of the corporation. And you will note that too on the complaint, when we listed her, under her name, we designate her as the principal officer of the corporation. And that is how she is listed on the 990. Now, the IRS has rules, as we know, regulations, and they define what that means. And the definition of principal officer is the person who has ultimate responsibility for implementing the decisions of the organization's governing body or for supervising the management, administration, or operation of the organization. That would seem to make her a responsible party for the campaign materials that were issued by her corporation that are the subject of this complaint. So it's not about whether she's the treasurer of the PAC. As you know, there is no PAC. We're alleging they should have had a PAC. Maybe she would be the treasurer. I don't know if she'd be the treasurer if they had a PAC, but she is the principal officer. And we filed it we included her in the complaint based on her voluntary designation of herself as the principal officer of the corporation. Which under the IRS rules makes her responsible for the decisions of the corporation. I'm taking my arguments a little out of order based on how Mr. Bry proceeded. Now, he also argues that a corporation is a single person and therefore cannot be a political action committee, because the definition of political action committee is a combination of two or more persons. This is an issue that was argued before, but we're arguing again. And our position is factually that you have to look beyond just the mere incorporation. In this case, we have evidence presented in the complaint where the corporation describes itself as being funded by many different people and organizations, that we are always adding new people who want to support our cause. In addition, I think the decision was in 2020. I was before this commission on the case called Obrensky versus Cleveland Future Fund, LLC. The Cleveland Future Fund was an LLC that ran multiple negative express advocacy ads against Dennis Kucinich, I believe, in the unless I'm mixing that up with another issue in Cleveland, but it was no, actually, I think it was on the school levy. I'm sorry, not the stuff involving Dennis Kucinich is a whole nother case. In that case, the attorney for Cleveland Future Fund specifically argued that because they were a corporation, they were a single person and therefore could not be a political action committee. The commission rejected that argument. So that is the precedent of this commission. You have to look beyond that to determine if it is a combination of two or more persons. And then the second half of the definition is whether the primary or major purpose of the combination of those persons is to influence the results of elections. So based on that precedent, the commission has already once rejected this argument, should reject it again. I would add that if the commission concludes that a corporation can never be a PAC, okay, because it's one person, then is it okay if I go tell all of my PAC clients, let's go incorporate and you'll never have to file another report? Okay, now it doesn't matter how many people make up your group. It doesn't matter that you spend your money to directly influence the results of elections. You're a single person. You don't meet the definition of a PAC, and therefore you won't have to file reports anymore. That would be the policy or the outcome. And this was the same argument that I made in the Obrensky case. And the commission rejected the other side's argument. So I would request that you reject it again. Now, with respect to the rights of corporations and the law and advisory opinions of this commission, I will say that Mr. Bry, I think, is being creative in how he is interpreting those things. Let's start with the case of Citizens United. Citizens United was a challenge to a federal law that was nearly identical to Ohio's corporate ban. It said corporations cannot use their funds in connection with elections. Okay. Citizens United challenged that on the basis saying, well, we're not making contributions to candidates, but we want to spend money on ads expressly advocating in the election. The US Supreme Court decided, number one, that corporations do have First Amendment rights to engage in political speech. That was actually nothing new. But they then had to go on to determine whether this restriction on corporations' rights, their constitutional right to engage in speech, whether the government had an overriding justification for restricting First Amendment rights of corporations. And the US Supreme Court concluded that the federal government's interest in restricting independent expenditures was not sufficient to justify a complete ban. So corporations could engage in independent expenditures, supporting or opposing the candidates of their choice. Mr. Bry basically, I think, takes the case a step further, which is not what the holding of the case is. And he says that the court also determined that that corporations could not be subject to any regulation of that speech, or that they could be required to file PAC reports. That is not actually what the court did. What the court did in that case was consider an argument put forth by the federal government in defending the ban, saying, well, corporations still have an avenue for political speech without using their corporate treasury money. They can form a PAC and they can speak through that. They can sponsor that PAC. They can pay the administrative expenses of that PAC. They just can't fund the PAC. That argument was rejected by the US Supreme Court on the basis that that might be an alternative way to speak, but it did not address the underlying fundamental question, which was whether the federal government had overriding interest in prohibiting the use of corporate treasury money for independent expenditures. So yes, the court said that you can't require the corporations to set up PACs in order to speak, because they can do it through independent expenditures. But again, that was the only reason that issue was coming up in that case. The Supreme Court in Citizens United never dealt with the question of whether a corporation could ever be a PAC based on the amount of its activities, based on its purposes, based on the federal definition of a political action committee, which is very close to the Ohio definition. That was not the issue. That's not what Citizens United, the corporation, was about. It was solely about the complete and total ban on corporations engaging in independent expenditures. So from there, he goes to, Mr. Bry goes to the commission's advisory opinion, number 2010-02. And he says that this opinion provides that there is no requirement for corporations to register as PACs or to form or to file reports. That's not in there, okay? He may be interpreting it that way, but in that advisory opinion, the commission simply said that it was following the decision in Citizens United, and it was going to interpret the Ohio statute, which had the nearly identical ban on any corporate speech involving elections. And the commission said in the opinion that based on Citizens United, we will not enforce the state statute that and corporations can now engage in independent expenditures. This opinion did not, just like Citizens United, this opinion did not reach the next question of whether a corporation that meets the definition of a political action committee, meaning its primary or major purpose is to influence elections, would have to register and file reports. You won't find that in here. So Mr. Bride takes this opinion much further than it actually goes. And hence his statement that you will need to, that they were okay to rely on this advisory opinion, and that the commission would need to amend its advisory opinion if it was to change its view. That doesn't hold any water, because again, it is he that is taking this opinion beyond what it actually says. He also cites to the Speech Now case versus the Federal Election Commission, which was decided by the the Court of Appeals for the District of Columbia. And the basic issue in that case was whether or not a group could take whose only purpose was to influence elections and was only going to do independent expenditures, whether or not it could take in unlimited contributions. Because again, there's a federal contribution limit, right? The FEC had said, you're a PAC, you come under the contribution limit, okay? That's what people can give to PACs. They challenged that in federal court. And the federal court held that that the limit on contributions could not be sustained, because they were only being used, the contributions were only being used for independent expenditures. Therefore, this group could take unlimited contributions. And of course, we know it can engage in unlimited spending on independent expenditures. However, in this case, the Court of Appeals also held, and this is on the FEC website, they have a summary of the litigation. They basically held that the reporting requirements can be imposed on this group, and they can be required to file reports of their contributions and their expenditures. Because, why? Because this was their reason for existing, was to influence the elections. So they could take unlimited amounts of money and spend unlimited amounts of money, but they still had to engage in disclosure. That is what we are alleging in this complaint. So the other thing that Mr. Bride has mentioned this morning is that the commission has said that that PACs cannot incorporate. I'm a little bit of a disadvantage in that I don't have that opinion right in front of me, but I know over the years I've incorporated PACs, many PACs. I've incorporated at the state level, the Ohio level. I've incorporated state campaign committees, and it's always following the same model as under federal law, which is you can incorporate as long as you include language in the articles of incorporation that this is for liability purposes only. Okay. Long ago, the feds said that was sufficient to get around the corporate prohibition, okay? That it says that corporations can't use their funds or property in support of elections, candidates at the federal level. So we have done the same thing in Ohio. And if the opposite was true, okay, if this kind of is circular in a sense, it comes back to one of the things we've already mentioned. If his argument is you can't incorporate a PAC. So if you can't incorporate a PAC and you just incorporate, therefore you're not a PAC, therefore you don't have to file, even if you are really acting like a PAC, right? It's a circular argument that I think does great violence to the actual Ohio statutory scheme. So the other thing I'll mention is that independent expenditures are reported by PACs. 3517.105 revised code sets out filing requirements for independent expenditures. And Mr. Bry brings up one thing, and which people get to take advantage of, which is that a corporation that makes independent expenditures against candidates, okay, assuming it's not a PAC, okay, if it's not a PAC, it just has to report. Well, actually, Ohio doesn't have a way for them to report, okay? Ohio does not have a way for those corporations to report, but that doesn't get to the underlying question of whether that corporation is a PAC, because if it is a PAC, it does have reporting requirements for its independent expenditures. It has those reporting requirements under 3517.105. So, you know, we have these some initial legal questions about mootness and one person, but the ultimate $64,000 question is whether or not incorporating means that you can never be a PAC, no matter if you otherwise fully meet the definition of a PAC. So I would respectfully request that the commission reject the recommendation of your staff attorney. I will note, I know that this is a new proceeding. It's the same recommendation that was made last time. You're looking at this anew, and that's well and good. But last time that argument was that recommendation was rejected, the commission found that there was sufficient probable cause to set this matter for a hearing. We would request that you do the same this time. Ultimately, what is kind of overshadowing, I don't say overshadowing it, but what's the big non-legal question? The big question is disclosure, whether in the legal question related to that is it a PAC, and can you avoid becoming a PAC by incorporating? That's kind of this, as I said, the $64,000 question. But what the result of that would be even more dark money, meaning money that is not required to be reported in terms of where the money comes from, because PACs have to report on both sides of the ledger. And if you meet the definition of a PAC, then you should have to register and file those reports. Thank you.
Thank you. I will try to respond more or less in the order in which Dominic Tyke presented his arguments. First of all, he said that civil actions, proceedings, can go forward under some circumstance. First of all, proceedings in the context of that is referring to court proceedings. It's referring to proceedings where your life or liberty is on the line in a criminal matter, or proceedings in which money is at stake in a civil matter, or injunctions or that sort of thing. It's not referring to what we commonly call proceedings before the Ohio Elections Commission. Secondly, he's saying, well, he named the individual because she's a responsible person, and we're supposed to name the responsible person. But if you take a look at that paragraph in which responsible person is talked about, it's after you talked about treasurer, candidate, and those sorts of things. You can be responsible in an IRS sense, but we're not the IRS, without being somebody who has any statute imposing any liability on you. Because the rules of this commission and the revised code require that you specify what statute a respondent is alleged to have violated. And there is no statute that alleged a quote responsible person under IRS verbiage is violating anything. If they're not a treasurer, they're not a candidate, they're not someone who misused funds in a way. You can accuse anybody of a campaign violation if they fit the definition, somebody who'd be accused in the statute. But you just can't say, well, they're on this form 990, therefore we can sue them because they're responsible for something. Maybe they are, maybe they're not. But you don't get to just throw somebody to the wolves because you want to. Thirdly, although this is kind of minor, he's reversed the order. 2 or more people. It's funded by many people, and therefore it is 2 or more people. If I understand his argument correctly. Well, the Ohio Secretary of State has expressly stated, because the Ohio Administrative Code expressly states that 2 or more people does not include people contributing to the entity. That's a black letter matter of Ohio law. And he just asking you to ignore that. 2 or more people cannot include people contributing to the entity. Oh, and by the way, he brought up again a revised code 35-17-105 and correctly said that a PAC or campaign committee or those sorts of entities, if they make independent expenditures with respect to candidates, do have to report them under 35-17-105. But corporations are listed separately. And corporations are listed separately because they're separate from those other entities. And corporations have different rules under the independent expenditure disclosure requirement 35-17-105. And as Don McTighe acknowledged, corporation per se has no duty to disclose independent expenditures of candidates, just like this commission said in its advisory opinion. Now, Mr. McTighe then accuses me of misrepresenting what those advisory opinions said. And I take that seriously, because I did not misrepresent what those advisory opinions said. So I'm going to read you verbatim what your own advisory opinion said, and you decide whether I'm characterizing them correctly or whether Mr. McTighe is being creative, as he used it. The court's decision in Citizens United allows corporations to participate in candidate campaigns as long as there is no direct contribution to or coordination with either a candidate's campaign committee or a partisan political committee. The Supreme Court did maintain a ban on direct contributions to candidates or political parties from corporate entities. And then I'm skipping the paragraph where the commission states that a corporation, as long as they act in concert with the holding of the U.S. Supreme Court, Citizens United, and conduct their partisan political activity totally independent of and not coordinated with a candidate or political party, then we're not going to hold them in violation of Ohio's laws that say you can't do that. Then there's the paragraph that Mr. McTighe says I'm misrepresenting. It says, well, there is no specific obligation currently in Ohio law, which I interpret to mean there's no specific obligation currently in Ohio law. The commission would encourage any corporation that desires to involve itself in the partisan political arena, as allowed by the court's decision, to file a statement that reflects its activities with the appropriate file law in office, similar to the Form 30B1 that reflects the corporation's contribution to a ballot issue committee. And that's what you said. I don't think I'm misrepresenting that. I don't think I'm being creative about what you said. I think I'm reading what you said and telling my client that you can rely upon what you said and you can act upon what you said. And Mr. McTighe accuses me of being creative or disingenuous. Secondly, he accused me of being creative or disingenuous about what Citizens United said. He said Citizens United never dealt with the question if a corporation could be a PAC. It's only about a total and complete ban of corporate campaign issues. Okay. Well, let's read from that portion of Citizens United and see if in fact they did address the notion of whether you can require a corporation to be PAC if they spend independent expenditures. And the U.S. Supreme Court here says Section 441B is a ban on corporate speech, notwithstanding the fact that PAC created by a corporation can still speak. And I'm skipping the sites. Even if a PAC could somehow allow a corporation to speak, and it does not, the option to form PACs does not alleviate the First Amendment problems with Section 441B. PACs are burdensome alternatives. They're expensive to administer and subject to extensive regulations. And then skipping down, PACs have to comply with these regulations that the Supreme Court cited in length, and I discussed in my first presentation, some of them. This might explain why fewer than 2,000 millions of corporations in this kind of country have PACs. Now, Mr. McTighe correctly notes, as I stated in my briefs and in my arguments, in federal law, because federal law is different than Ohio law, you can require reporting of independent expenditure entities. And they said that in Citizens United, and yes, they said that in Speech Now as well. You can require them to file reporting of their activities. And you could require that in Ohio, or actually you couldn't, the General Assembly could. You know, this commission is stuck with the laws as they stand, whatever policy arguments. And Mr. McTighe said, well, you know, this would be bad policy because after all, you know, you can have LLCs and therefore I made the argument about the LLC. We talk about LLCs, they're partnerships for purposes of election law. There's no precedent at all about whether a corporation can be more than one entity. But otherwise, I just tell all my clients, let's incorporate as a PAC and never file another report. Okay. Here's what would happen if you did that. You would be an independent expenditure entity. You couldn't coordinate, you couldn't contribute, you couldn't have inside knowledge, you couldn't do all the things that PACs customarily do in Ohio. But yes, you can form a corporate independent expenditure entity. That's legal. It's a constitutional right. The United States Supreme Court said it was a constitutional right. The DC Court of Appeals said it was a constitutional right. Now, Mr. McTighe also accuses me of misrepresenting what Speech Now said. I did not. The FEC says if you're a PAC, you're under contribution limits. Well, if you are a PAC in Ohio, you're under contribution limits. Federal law apparently can capture entities without them being PACs if they're engaging in independent expenditures without being a PAC, because they're not subject to all the requirements of the PAC and cannot constitutionally be made subject to all the requirements of the PAC, but could be made subject if the law said so to reporting requirements. But Ms. McTighe isn't saying, let's write a letter to the General Assembly and tell them to change revised code 35-17-105 and say, add into that corporations that make independent expenditures about candidates ought to disclose those to report them. It could do that, but this commission can't. This commission, you know, every one of you, and I trust your judgment, are taking an oath to uphold the laws under the Constitution as they exist, not as we would like them to be. We can make all kinds of policy arguments, but ultimately the General Assembly has authority to change the statutes. We don't. Lastly, Ms. McTighe says, well, corporations can be incorporated because I've incorporated some. Okay, I don't know whether he acted properly or not. Maybe he incorporated them, but did it through the feds. Some people do that. Matter of fact, I've formed some folks that have filed with the FEC to become super PACs and filing with the FEC, even though they had no intention of doing any federal electioneering activities. You know, there's some advantages and disadvantages of fully disclosing where your funds come from and where they're spent. The advantages are you might be taken more seriously because people aren't going to be accusing you of dark money. The disadvantages are people who fear, as the members who contributed to One Worthington feared, retribution from folks for their speech activities may be a lot less likely to speak, which is why One Worthington went out of business, because they were chilled by the complaint, by the 1.5 year delay to 2.5 years since the complaint was filed in sorting this thing out. And therefore they went under. And that's, you know, it wasn't a strategic decision, but it's a practical one. The feds said you could, but just the fact that Don McTighe has done it or says he has done it with Ohio without doing the federal thing, that doesn't make it precedent. I can also tell you, by the way, I have advised clients on setting up independent expenditure corporations and told them that they have no duty to report. And therefore, that must be the law. If you're persuaded by him, you ought to be persuaded by me too, all right? You know, in other words, I do believe that's the law. I've given seminars on that. and handed out sheets explaining the difference between a political action committee, a campaign committee, a C3, a C4, a C Corp, what they can do, what they can't do, whether they're involved in federal versus state or local. And I've always told them what this commission told me and told my clients, that under Ohio law, if all you do is state and local and you are a corporation, and you have no duty to file a report of your stuff anywhere. I regret that Mr. McTighe felt it was appropriate to accuse me of misleading the commission in terms of what its own advisory opinion said, but you can read it. I attached that advisory opinion 2010 ELC 02 to my original motion to dismiss. It's there. It's a page and a half. You have 2 pages at most. You can read it. I've quoted it to you. You know what it says. And I would respectfully request the commission not punish us for doing what the commission told us we could do. And I would also suggest that it's somewhat, I'm trying to think like word, it would be inappropriate to use a question about the law. What should the law be? What should this commission's advisory opinion say to punish someone who has already relied upon them? You can change them on a going forward basis, but the Ohio Revised Code says we are immune from every civil or criminal penalty. And I believe that includes the procedure that we're talking about to have a hearing against us. If we rely upon it, and we have. There's nothing in advisory opinion 10 ELC 02 that says only certain types of corporations don't have to file. There's nothing there that says you don't have to file unless that's most of what you do, in which case you become a PAC and have to file this. There's no requirement. There is no requirement. And if you think that opinion was wrong, fine, change the opinion. But don't have a hearing against my client for doing what you told it to do. And therefore, I would respectfully suggest that you follow the legal advice of your legal counsel and understand that, one, you can't proceed against the corpse of a corporation. 2, you can't proceed against somebody who there's no statutes or statements that she did anything that violated the statutes because she's not the treasurer, even though he says she's a kind of sort of treasurer. And 3, even if none of that were true, Citizens United and this commission's own advisory opinions gave us the right not to be required to be a PAC and not to be required to report independent expenditures. And by the way, Mr. McTighe is not claiming that we had a duty to report independent expenditures. He only wants us to be declared to be a PAC, which would impose unconstitutional requirements in terms of contributions to and from the PAC.
Thank you. I'll be very brief. I don't recall saying that Mr. Bry was being misleading or misrepresenting. I think I said he was being creative and taking things a little further or too far. Which I still stand by. I think that neither Citizens United nor the Commission's 2010 advisory opinion ever reached the question of whether or not a corporation could also be a PAC. That advisory opinion followed Citizens United. That's as far as that advisory opinion goes. And Citizens United was not about whether Citizens United was a PAC. It was about whether or not the corporate prohibition on using corporate funds for independent expenditures could be enforced. Thank you.
I apologize if I misheard what he said. He's partially right and partially wrong. Under federal law, a corporation can incorporate for liability purposes and become a PAC. But under Citizens United, an independent expenditure corporation cannot be required to be a corporation to become a PAC. And that was the gist of the portion of Citizens United that I read to you.
So I have a couple of questions actually for both of you. And I have a comment. And I hope you take it for what it's worth. Watching you two argue back and forth is like poetry or a good tennis match. You are both excellent, in my opinion. I didn't want to not say that to you because you're obviously both very confident individuals. But I do have questions. I remember when we did this first, because this is now what, our third time, I guess. But when we did it initially, I understand, Mr. Bry, you were not here. But the commission, we had a number of questions about this entity, and it was based, as I recall, and anybody can help out here if I'm leaving something out. But when we looked at Worthington One's website, and I'm on there now, and I'm looking at One Worthington's website. I'm sorry, it says, this is, I will get up those over here and I'll read it. It says, consider donating to help spread our message as an informative resource. Funds raised by One Worthington will go towards several tactics, including distributing community-wide mailers, communication assistance from experts in the field on sunshine law violations, and board ethics, and finding new candidates for the Worthington One School Board in 2021 election. Thanks for visiting our page. One Worthington is a 501c4 and donations are not tax deductible. So let me finish here because I have a number of things here. So my understanding, so when I'm looking at this, they're incorporated. Okay, I get it. They're not a corporation like GM, but they're incorporated. I understand that. But they're also saying they're a 501c4. And my understanding about a 501c4 is that their activity political activity has to be less than 50%. Right? And this was one of the issues we had, like I said last time. Of course, we weren't here, but there was, I think we wanted to, again, we're looking at a probable cause standard here. We wanted to know what they actually did on a daily basis. We wanted to know, are they doing education? Are they doing all political? You know, my further understanding is that 501c4s are akin to a volunteer fire department. They're akin to a Rotary Club. So when we look at all this and I hear the arguments on the independent expenditure, but me personally, I'm concerned when I see in the website that it says finding new candidates. I don't know how you find new candidates when you don't coordinate. I don't think somebody's going to just run John Lyle for city council without having some communication for me or towards me. It's so, you know, we have hear what both of you are saying, that when I look at this, it's not square, and that's why I'm tipping towards probable cause based on their own words.
I'm sure I have a few questions.
I'm sorry, is that a question?
Yeah, no, I did have questions. I mean, it said questions for both.
Yeah. First of all, a 501c4 doesn't have to be a corporation. You can have entities that are tax exempt under federal law, or IRS law, under 501c4 without being, they're a corporation without being corporations. So the fact that there have been some clubs, that have 501c4 status, maybe they're incorporated, maybe they're not. But you can have for purposes of Ohio election law, the critical mass is not whether you're a C4 or anything else, but whether you are a corporation under chapter 1701 and 1702 of the Ohio Revised Code. Secondly, there has been no allegation of coordination by either side. Until you mentioned it or suggest that maybe there was. There's no evidence of that. There's no personal knowledge or allegation of that. Maybe this is something they intended to do but never did. Maybe they did it without coordinating, but is without dispute. No one disputes that in any of the things that have been filed, that all of our activities, our political activities were independent, uncoordinated expenditures. If they've got evidence of that, then fine, they can file something or could if we weren't already defunct. But no, the fact that you find the stray word in there doesn't necessarily mean that that's what happened. As you recall, and I think Don McTighe pointed this out in his original complaint, originally they screwed up and called themselves a C3, which C3, as you know, can't do any political activity. And they would have been big problems, not with you necessarily, but with the IRS, and they cleaned that up that they were C4. My guess is this is probably just another stray word, but stray or not, the fact is no one has accused them of that. And because no one has accused them of that, we haven't bothered to spend much time defending.
So in your opinion, they're a corporation in an independent expenditure that runs independent expenditures?
That is the understanding, yes. And by the way, I don't think there's any dispute about that. Nobody disputes about the fact they've done independent expenditures. And there's been no dispute or.
I mean, that's their primary purpose, is to run independent expenditures.
I'm not saying that's their primary purpose, it's not, but that's a fact question. I'm saying that, that if you're saying it matters how many independent expenditures they ran, that would involve, I suppose, in your mind, if I'm reading correctly, you would say, well, if they engage in violation of the C4 status and ran too many independent expenditures, would then they become an Ohio tax? Because remember, the IRS has authority to enforce IRS rules. This commission has authority to enforce that portion of Title 35 is within its jurisdiction. You're not the IRS. And the argument that I presented was assuming even if 100% of their activities were all independent expenditure activities, they still can't be required to do everything an Ohio PAC is required to do. They can't be declared to be an Ohio PAC. You would be declaring them to be a square peg and trying to shove them into a round hole because they have a constitutional right to do things that Ohio PACs cannot do. And frankly, they would have Ohio prohibitions about doing things as a corporation that other Ohio PACs got.
So, Mr. Bragg, could you tell us what their primary function actually is as a one word?
Social welfare. But there's an affidavit attached to original motion to dismiss that talks about that in general terms. Now, having said that, the reason I've stayed away from arguing that the line drawing problem is precisely because the argument that you're presenting. If it is a question of how much independent expenditures they do, or whether that's really their primary activity, are they lying about doing the most of their activities of social welfare? I mean, we have an affidavit to that effect. There's no affidavit to the contrary, but there's all that stuff on their website that you've looked at. And Mr. McTighe has attached the complaint saying, well, maybe we need to find out how much they do. And my answer is, no, you don't. Because even if they do 100% of their activities in violation of their C4 status, even if they did 100% of their activities, just like Speech Now did in the Speech Now case, as independent expenditures, they would have the same right as Speech Now had of not to be subject to all the PAC rules. Under federal law, yes, you can be required to report, but you can't be made a PAC for purposes of all of Ohio's PAC requirements. And if Ohio wants to have a separate requirement, as the feds do, for entities that aren't PACs, but they still want them to report, they can amend Revised Code 3517-105 anytime they want to. Does that answer your question?
Somewhat. Thanks.
I apologize for my rudeness about a chart into the specific piece that I wanted to be able to reference. I didn't want to lose this for a bit. I'm good. Maybe it wasn't.
As a sort of reply to that, there's no need for the General Assembly to change Ohio law or amend Ohio law. Ohio law says what it defines a PAC. Okay. And if you meet the definition, you're a PAC, you have to register and file reports. I could go out and I could register. I could file a designation of treasurer form and register a PAC, and I could just 100% of my activity might be independent expenditures. And I'd file reports where I got the money, how I spent the money. Fine. The difference here and I'd be a PAC because my primary or major purpose is to influence elections through independent expenditures. That is what is alleged is being done or was done by One Worthington. Their out that they're claiming is they were incorporated. So it doesn't matter, but it does matter because, again, what has not been decided yet, I think, by this commission in its advisory opinions or, well, and it's, at least in its advisory opinion, is whether or not simply incorporating means that you won't be a PAC, regardless of your purposes. I think that argument was rejected in the Obrensky case by the commission. And again, I would ask that you find probable cause here. Thank you.
Well, once again, I would point to the reason this commission's advice that you don't have a reporting requirement, which would include reporting requirements of PAC, is because a PAC under the express language of 35-903 cannot receive any use of a corporation's money or assets or activities. And if the Ohio Revised Code says a corporation can't fund a PAC, be a PAC, yes, it could have a separate entity, and there are rules about corporate entity PACs, then the rest of the Ohio Revised Code definition of PAC hasn't changed. Corporations can't be PACs. Now, I understand that the advisory opinion 2010 ELC02 said that we're not going to force that provision to folks that are operating as independent expenditure entities. That's true, but it still doesn't change the rest of the revised code that views impaired material. What did they mean? What did they mean? What they meant the day before Citizens United was that whatever else we mean by political action committee, we don't mean a corporation. And what they mean the day after Citizens United, as in terms of what a PAC is the same thing. Maybe an argument could be made that a PAC could voluntarily, or a corporation could voluntarily become a PAC, although I don't read the Ohio's law that way. But you're not required to do that, and the U.S. Supreme Court said that.
Yeah, Mr. McTighe, you referenced Obrensky a couple of different occasions, and I've got I have the consent order that was entered into by all parties in that case. And first off, I mean, I don't see within it any acknowledgement by the commission that there was an assertion that there was a corporate entity in violation of the statute. It's you know, it is a consent order that your client entered into with Cleveland Future Fund, but it's Cleveland Future Fund LLC. It's a limited liability company. It involved a ballot issue. It involved a school issue in Cleveland at the time. And what it says is first off, Cleveland Future Fund does not admit to any of the violations alleged in either of the complaints. There were two complaints. One alleged a disclaimer violation, and the other one alleged a variety of campaign contribution filing violations, including 105C. But then Cleveland Future Fund agreed to go ahead and disclose to the complainant all sources of funds and in-kind contributions received by Cleveland Future Fund since its inception through the date that the order was adopted. This is in June of 2021. Disclosure will include names and addresses of all sources, balance dates with respect to the sources of any monetary and in-kind contributions. Cleveland's Future Fund also disclose the original sources of funds contributed to any third-party entity. Cleveland's Future Fund LLC will disclose all expenditures it made in opposition to the Cleveland Metropolitan School District levy. So it's a levy issue, not necessarily the candidates. Disclosure set forth above shall be made no later than 7 days, which was eventually complied with. And it made a contribution to a Cleveland nonprofit organization. So there was no actual finding, at least as I'm reading this, there was no actual finding by the commission of a violation of the statute. This led to a subsequent dismissal of all the complaints by your client. after this was complied with and once the filings were made. So essentially, I think what you have there is an LLC that was operating as an independent expenditure organization. And then by making all of those disclosures, it essentially came into compliance with 3517-105 by disclosing to your client, and presumably, I believe it filed reports with the Cuyahoga County Board of Elections as an independent expenditure under 3517-105 as it related to a ballot issue in the city of Cleveland. I just wanted to make that clear based on my reading of the consent order. The commission did enter it.
The argument that they made the argument that an LLC was a single person under the general definition of person in the revised code. That argument was made at the preliminary review stage, and I argued against it. The commission set the matter for a hearing, and then we entered into the settlement. Okay. Ergo, at least it would appear that the commission rejected that argument, that if you are an LLC, as I'm arguing here, if you're a corporation, you could never be a PAC, because that was the argument they made. I argued against it. And if the commission agreed with them, they would have dismissed the case, but they didn't. You didn't dismiss the case. You set it for a hearing.
Sorry.
One addition to that, I think the issue about what percentage of their activities were political, as well as the issue of were they two or more people, are a little bit of red herrings. And the reason I say that is that speech now involved an unincorporated association of several people, clearly more than one person. And all they did, 100% of it, was independent expenditures. And yet, the unanimous DC Court of Appeals held that under Citizens United, which had been decided 2 months ago, it was unconstitutional, the violation of the First Amendment, to require them to comply with all of the requirements of a PAC.
Thank you very much. A couple of questions. First of all, I'm bad with names, Mr. Bry, and
Or you can say Don and Don, but
that
won't help.
Bry,
McTighe.
I you know, is it Bry or Bray or McTeague or McTighe, right? So I may say complaint, you know, the complainant or respondent, I get a. So a few questions. Mr. McTighe, you made a comment during your presentation that talks about all of your clients, you know, your PAC clients that obviously have to go through the disclosure requirements to follow Ohio law. And that if, you know, there wasn't a requirement, that you would probably just advise them to form a C4, right? So because they were a corporation, I'm sorry, because they wouldn't need to follow any reporting requirements. Is that, can you elaborate on that a little bit for me?
Certainly. So the argument that's being made by the respondents is that a corporation is a single person, is a single person, is a single person. The first half of the definition of a PAC is a combination of persons. So there's no combination. Okay. So if I have groups that are unincorporated associations that are PACs, because that's they fit both halves of the definition, combination of people and primary purpose to influence elections. They meet both definite halves of the definition. But if we eliminate the first half and say by incorporating, you're not a PAC, then my PACs could incorporate and not be PACs. Okay.
There is a caveat to that. Under the advisory opinion that we've cited several times, 2010 ELCO2, not only did it say that corporations that follow Citizens United and only do independent expenditures that's legal. It also says it continues to be illegal for any corporation, any direct contribution to a candidate, campaign committee, or political party will continue to be a violation of 3599.03. So if Mr. McTighe incorporated those folks, they darn well better be acting purely as independent expenditure entities, because if they made a contribution to any candidate or political party, they would be breaking Ohio's law.
Thank you. Mr. Bryan, obviously, whether or not, in this, my opinion, one Worthington is, meeting the threshold of social welfare. I understand that is not the issue before this commission. But is it accurate to say that this organization would have had to report to the Internal Revenue Service of their activity and what candidate and or issue that they had supported in their filing? I'm sorry, I don't know what the form is called. Would they have had to disclose that in any federal forms?
I know that they would file, there are forms they need to file with the IRS. I don't necessarily think they're public forms. Some of them are, some of them aren't, depends upon the nature of it. In terms of their political activity, I don't believe so. I may be mistaken about that. I know that it used to be, before Citizens United, we were all talking about 527 groups. And 527 groups were groups that avoided express advocacy of election defeat and said, write Senator Smith because he is against the Kumquat bill, and we need to protect Ohio's Kumquat, something like that. And you could do that, and to the extent that you're indirectly trying to influence an electioneering campaign, 527s did have reporting requirements along the lines you're talking about. After Citizens United came out to 2010. What we call 527s became much less popular because a better way to do it is make sure you do independent expenditures only, uncoordinated expenditures, and don't make any direct contributions. And therefore you can act to your heart's content. Although, as we've seen over a number of election cycles, more advertising by independent groups doesn't necessarily mean that they effectively get their message across. Sometimes it actually hurts their message because you have people that have no connection with the candidates and are really cutting the legs out from under what the candidate wanted to do in their campaign or the issues they wanted to emphasize.
Well, first of all, Ohio's fruit is the pawpaw, not the kumquat. So we'll start with that. I believe that's correct. Well, yes. Beyond that, we're getting really it's getting kind of deep into the weeds here, but federal law requires corporations that make independent expenditures to file reports on the federal candidates that they supported or opposed. Okay, so there's a federal law on that. Ohio doesn't have a state law. Okay, because the General Assembly hasn't done anything to address, the effects of Citizens United. However, again, that isn't that is all based on the assumption that you're not a PAC, that you are a corporation, which means you have a primary or major purpose other than influencing the results of elections. So you can still fit the definition, even under federal law. You can incorporate and fit and if you incorporate and fit the definition of a political action committee, you have to register as a PAC and file PAC reports. If you don't fit the definition and you're a corporation, yeah, you file independent expenditure reports. Sure. Next.
Thank you. Thanks. I guess. Or and let others answer after questions.
Just a quick response. Federal law allows corporations to support PACs if they are the corporation incorporating the PAC. The language of Ohio law in 359903 prohibits that. That's what is the difference between being able to incorporate as a federal PAC, even if you're a corporation, and Ohio's laws on the definition of the PEC. And even if permitted, you cannot require someone to do something that the words of the Ohio Revised Code prohibit them from doing.
I just have a couple, I think, questions. One's, when I looked at, this will be directed to Don. Which one? When I looked at that, I believe it was Miss Edwards, form filed on her behalf. There was the original creation of the 501c3, I believe it was in August of 2020. Then it was amended to be a 501c4. And with those documents were like a board of directors, a vote that they made, the resolution. Yesterday we got, I believe from Phil, was the dissolution one. I guess my question to you would be, was there document, I don't know Ohio law well enough when you do a dissolution of your 501c4. Was there documentation that they had to provide? I just similar to that, a board of director motion, since they're basically terminating and then the money left over, because I was wondering if there was anything there, because we're talking about the 50% threshold, and if there's money that went to a campaign, I was wondering if there was any documents that were sent to the Secretary of State when you forwarded that time.
There were actually, I think, 5 or 6 pages attached to the certification that I submitted on Tuesday. They don't really tell you a whole lot. And I mean, I thought about giving it to you, but it doesn't give you any other names other than Ms. Edwards, if that's what you're looking for. Our firm didn't do it. So, you know, I don't have the inside information on what was done. But, you know, I have what's on the Secretary of State's website. It's available online, but it's not that informative.
And the other thing, and maybe this is maybe Phil, you could help direct. So there's a lot of stuff about the last hearing. I appreciate all the information, but the commission ruling, could you explain what went into there? Because much of this looked like a political campaign, the campaign that we're used to with PACs and all that. But in the commission's ruling back in, was that 2010, they said such a filing, they encouraged the filing if it's for political purposes. Such a filing would manifest the foundation of Ohio's campaign finance law, public disclosure. Was there any discussion, I guess, of the commission at the time as the kind of the case we're here, and maybe in the future, yeah, that's just a recommendation, but what happens if this then becomes the norm? And I'm not sure if anybody has in the past, you know, publicly said we're going to file a form anyway. So did the commission have a discussion about what kind of what the consequences, I guess, would be if people didn't kind of go along with the recommendation that we advise you at least to file the public disclosure?
Yeah, simply stated, yes. After the decision, I wrote that opinion, and after the decision was handed down by the Supreme Court, and realizing that, you know, the nature of Ohio's law, and its essential similarity to federal law, I wrote the opinion that has been referred to here for the commission's consideration. And I've said this before, primarily to forestall anyone from rushing to court, filing a challenge to the Ohio's 359903 under 1983 action, and essentially enriching themselves, lawyers enriching themselves by challenging a statute that they were going to win because of the Supreme Court's decision. Like, you know, I certainly made that clear to the commission, but I also declared or discussed with the commission the ramifications of the opinion, my belief of the need for it. And, you know, one of the things that I made sure I included in there, you know, was the fact that there was in the, you know, because 3517-105 had been written at a point when prior to Citizens United, when corporations couldn't act in candidate campaign committees, when the General Assembly enacted 105, they did not include anything in there for, that obligated corporations that involve themselves in candidate campaigns, only in levy campaigns to make 31 filings. And when the commission approved that opinion at the time, probably go back and still find the letter that shortly after the commission approved that opinion, I sent a copy of it to all the legislative leaders, Speaker of the House, President, Senate, minority leaders on those sides. Let's just say encouraging, making them aware that corporations are not, or we're not obligated to file the equivalent of 31 if they involve themselves in activities in favor of a corporation or of an individual candidate, to make them aware that, were they so inclined, something should be done to place that obligation out there. Needless to say, here we are, 13 years later, nothing subsequent has ever been done. The General Assembly has never otherwise acted to place any kind of an obligation under 3517-105 on a corporation similar to a corporation that involves itself in a ballot issue campaign. And so, yes, all of those issues were discussed at the time. The commission approved the opinion. Like I said, I sent it along to the various leaders of the General Assembly. And there was never, my understanding is there was never an interest in extending the obligations under 3517-105 to include corporations that involve themselves in candidate activities. Hopefully that answers your question.
Can I add something to that? Essentially, that summary, I believe is correct. I wasn't involved at all in the opinion. Obviously, I think it was sua sponte by the commission. But what's getting lost in this summation is that the opinion came out basically to follow Citizens United. Citizens United was only about whether or not you could prohibit a corporation from using its corporate money to engage in express advocacy. That's what Citizens United was about. Okay. That what the U.S. Supreme Court said is, yes, they're allowed to engage, use corporate money to say vote for somebody or vote against somebody. The FEC then went and amended the federal law got amended to require those corporations to file independent expenditure reports. Okay. Ohio has not done that. Okay. But again, the underlying premise there is the scope of Citizens United. Citizens United was not dealing with the question of whether the corporation would also fall under the definition of a political action committee. Okay. As it was, that was not the question. That there was about using corporate money. Okay. It wasn't about whether Citizens United was a PAC. Okay.
Respectfully, the unanimous decision of the DC Court of Appeals 2 months later in Speech Now understood Citizens United rather differently than Mr. McTighe has just characterized it. And they found that it included something that clearly would fit the definition of a PAC. 2 or more people, 100% of their activities for independent expenditures still could not be required to become a PAC for all purposes. Yes, they could be required. He talked about federal law being different than Ohio law. They could be required to report, but they could not be made a PAC and subject to the contribution limitations, the expenditure limitations, the source of contribution limitations, and all the rest of the things that a real PAC in federal law and in Ohio law are required. So I would respectfully suggest that 7 members of the DC Circuit probably had a better understanding of the scope and meaning of Citizens United than the understanding that Mr. McTaggart just expressed.
I would just add, I disagree that that's what Speech Now did, okay? Speech Now basically said you do have to file, since your primary purpose is to influence the results of elections. They weren't even incorporated, okay? And they were just gonna do independent expenditures, influencing elections, and the issue was whether or not they would have to file PAC reports and be under the contribution limits that apply to what people can give to the PACs. And what the court, federal court said is that no, those contribution limits cannot be enforced, but the disclosure requirements can, which is what we're trying to do here.
And the reason they came out that way is federal law is different than Ohio law. In federal law, you had two baskets. One basket is you have to report. The other basket is you are limited on what contributions you can receive. Ohio law, with respect to PACs, says here is a PAC, and everything, both of those baskets apply to the one basket, the PAC. So if you put one Worthington into that one basket, which is the only basket we have in Ohio, we're going to be treated unconstitutionally under Ohio law, and you can't do that.
I have, I guess, a few comments, and I wanted to wait till other questions were asked before I did. Because it, huh?
I just have one.
Oh, go ahead, sorry.
No.
No, I'd like to go at the end of.
Okay, so for Mr. McTighe, so, question, so, Mr. Bry has, notice of dissolution, for the corporation. So, since he's that's been filed, I guess my question to you would be, why do you now not see this matter as moot?
Well, I'm assuming that the records of the corporation still exist unless they've, disappeared or been shredded or whatever. I don't know, but I'm assuming that they exist. And those, if the commission were to rule in our favor ultimately, then a PAC would have to be registered and reports would have to be filed showing where the contributions came from and where the expenditures went. Those reports would be, I guess, late, okay, because, but nevertheless, there'd be public disclosure. So there's still that objective, if you will, of requiring public disclosure based on this being a PAC, which is, of course, the big legal question to be answered. The fact that the corporation doesn't exist doesn't mean that the records don't exist. And also under the statute that I cited earlier, Mr. Bry kind of summarily dismissed it as not applying to administrative proceedings. I didn't see that in there in what I read. But we are prosecuting, we use that term with a small p, prosecuting a case here at the Elections Commission for a violation of law. And we believe that under that statute, the corporate entity, even though it is officially dissolved, still has ongoing responsibility. In fact, if it was like no longer an entity, how can Mr. Bry even be here representing them if it doesn't exist at all for any purpose? But it does in terms of the wrap up, what has to happen after the formal dissolution.
I don't believe I ever said I still represented them. I said they were dissolved and therefore you lack jurisdiction over them. but there's another individual who I also claimed it was frivolous to make any claims against her since she did not file as a treasurer in the designation of treasurer. And there is no statute that is cited, as is required under the revised code and the rules of this commission, stating any violation of the Ohio revised code over which this elections commission has jurisdiction, that to which she is responsible. And you know, so he's quite right. You know, I don't represent a corpse, but I do have a duty of telling the commission that you're putting corpse on trial if you can go forward against Juan Worthington. Oh, and the reference to proceedings dealing with courts of law it's not a proof text, but it is one of the areas in which it's used is revised code 2307.01, which refers to an action in civil court as a proceeding or certain other activities in civil court. It's sort of a reverse, but it's still sort of a linkage. I haven't been able to find quickly the definition, but I'm pretty sure proceeding is limited to court proceedings.
So, I wanted to wait till the end because, we had the original preliminary review, there's not be there. We had a really robust discussion on a number of things that I think should, if the commission should at least discuss or be aware of. I wanted to wait till the end because, if there was something materially different that was discussed, it would be, I think, less relevant. From what I've heard today, a lot of very eloquent and well-put arguments, but it's still basically what was in the complaints, the new information being the dissolution of the organization. So a few things I think were very poignant in the discussion. We spent time on the definition of a PAC, a combination of two or more persons, the primary or major purpose of which is to support or oppose a candidate, political party, or issue. Result of any election through express advocacy. And we talked a lot about and again, envelope all this in a probable cost standard, right? It's not ignorant, it's probable cost standard. If you envelope a decision that any corporation, and the prime argument here is that it's a corporation, therefore it cannot be attacked. Well, you would, I mean, that sets a combination of two or more persons. So literally, we would be potentially, again, probably cost this point, saying that if you wanted to avoid exposing publicly your donations, you just form a corporation and you can avoid that, right? Because the minute you become a corporation, you don't have the tax standard. Here, it does not delineate any of that. It just says a combination of two or more persons. So yeah, they did a corporation, but the question here is, should they have been a PAC from the beginning? And the second piece is the primary major purpose. And though we have an affidavit from Ms. Scott saying that it's not their primary purpose, if you pull up their website, the very first thing is, buy yard signs, get a yard sign. Best Davis and Steel School Board, right? And if you go through their website, I mean, there is almost nothing discussed as any activity. And when we had this case before us without Mr. Bray, the website was different. There was a whole bunch of information about a candidate as represented a complaint being, do not vote for her, she's bad. I mean, it was even more political than it is today. And again, in all due respect, the affidavit and in a couple of cost standings, in an absence of any other information, what we have before us would certainly show that's their primary purpose. And maybe there is documentation that shows the other things that they do, other expenditures that they make. But in the absence of that, it's I guess, it was our view at the time, and I've certainly heard nothing today that changes that. At a probable cost standard, it's hard to not move forward to hearing. But I mean, I welcome all the other commission members' thoughts, but I mean, that kind of is a synopsis, I guess, of a very, very robust discussion we had previously.
With respect, I opened my remarks with the presumption that none of the members of this commission would rely upon anything that happened at the prior hearings, since that prior hearing took place without me being there in violation of the due process.
Which is why I went to the end.
Which is why, if any member of this commission believes that they are relying upon anything that happened in the prior meeting, I think they have a legal and ethical duty to recuse themselves. Because we were entitled to a fair and open meeting of open-minded people, not people that say, well, since we had this unconstitutional meeting, because I didn't receive notice, and it happened there, then I'm going to rely upon what happened there, and you've got to move me off the base. I hope that I misunderstood your words, but if in fact, you know, that what the meaning is, since we did it before, you've got to prove that we were wrong to do something that we did.
That's not what I said. I said,
Okay, well, I'm
that exist today, right? It's all in the complaint. It's all in your response. Everything that I laid out is no different today than it was then. Maybe I shouldn't have framed it that way, but those are the clear issues here. And I mean,
with respect,
all due respect, there's, I mean.
With respect, I hope that I've misunderstood you, but we'll take a look at the words on tape. The fact of the matter is, what you heard, Seneca once said, he who decides without hearing both sides of an issue, though he decide justly, cannot by any means be considered just. Today is an opportunity to hear both sides of the issue, and I've tried to do that. And both sides of the issue are, this commission told my client in an advisory opinion that we have a legal right to rely upon, that we had no duty to report anything. That wasn't discussed at the prior hearing. Nobody mentioned that. It was in our papers, but that wasn't what part of the discussion was. Well, the question is it meets these other parts
of the recommendations of the director at the time, so I believe it.
Well, I understand. The other thing that wasn't focused on is why was it correct for this commission to do that? And it was correct for two reasons for the commission to advise my client. Number one, 359903 says a corporation cannot contribute or participate as a PAC. That kind of means the definition of a PAC cannot mean a corporation. It also means, by the way, that a PAC, a corporation, whether incorporated as a PAC or otherwise, even if they do it as a federal, state, and local, cannot directly give, you know, a corporation for an Ohio PAC cannot directly give to candidates, and you said that as well. So the notion we just incorporate, you know, we don't have to report anything. Yeah, if all you do is independent expenditures, not if you engage in the normal PAC activity. And by the way, you're also, you know, and secondly, the second reason is that 3517-105 is where you get what you have to file independent reports of independent expenditures on. That's where independent expenditure reports come from. And there's an express statement in there that says, well, corporations don't have to do it, but maybe if the corporation's a PAC, but 359903 says a corporation can't be a PAC. And more to the point, this commission told us that we didn't have to report. And if any commissioner is saying we should have ignored what you told us and know that it would be a violation or potential violation of the law by following what this commission told us, I don't see why anyone would pay any attention to any advisory opinions that this commission issues. We have a right to rely upon them. We did rely upon them. Just because the issue was not argued, maybe it was in paper somewhere, but there's a difference between something being in paper and something being presented in a way that you can understand. Because I got to tell you, even if you didn't say that, it is unconstitutional for any member of this commission to vote to impose campaign contribution limits upon an independent expenditure entity. Citizens United said that. Speech now said that, this commission said that in its advisory opinion. And if you do that, you are chilling speech and violating my client's First Amendment rights. And if you declare the potentiality by having a hearing saying, well, it depends upon how much you did, how much of your activities were in accordance with your 501c4 status. If you do that, you will be chilling speech. You will be violating the First Amendment under color of state law. And just like your legal counsel advised the commission 13 years ago, you know, if you do this, there's a good chance you're going to get sued and you're going to lose.
Yeah, I would just like to, Mr. Bry just mentioned something about contribution limits, imposing contribution limits. That's not part of this case. It's not alleged. It's not an issue. You know, if things are independent expenditures, then you can't limit the contributions. That we don't have any problem with that. That's just not part of this case. And again, just for the record, it's getting a little repetitive, but I think that Mr. Bry's reliance on the 2010 advisory opinion goes too far. I don't think that that opinion was saying that a corporation could never be a PAC. I don't think that was considering the context of a situation where the primary purpose of an organization is to influence the results of elections and fits the definition of a PAC. Thank you.
Contribution limits are absolutely a part of this case, because what Mr. McTighe's client is asking this commission to do, and what you're proposing to have or not have a hearing on, is whether or not we are a PAC. If we are a PAC, we are subject to contribution limits. If we are not a PAC, we're not. There is nothing, by the way, in the advisory opinion, 2010 ELCO2, that talked about contribution limits. That statute was not mentioned in that advisory opinion. The contribution limits that apply to PACs still apply to PACs. And if you declare us a PAC, or if you declare we might be a PAC if we talk too much about politics, if we engage in too much independent expenditures, if in fact there's more than one person involved, all of which was true of Speech Now. If you declare us a PAC, you are declaring that we're subject to contribution. Maybe that Mr. McTighe doesn't want to do that. Okay, we can talk about legislative proposals, all right? But you're not the legislature, and you're stuck with the law as it is. And you can't basically force somebody into a shoehorn that they don't fit into. So no. And by the way, the statement that 2010 ELCO2 doesn't say exactly what I said. Well, this is exactly what it does say. Forget about whether corporations can be PACs or not, all right? What it said is there's no specific obligation in Ohio law to file a statement reflecting independent expenditure activity. So if all we're talking about is you didn't file a statement reflecting independent expenditure activity, this commission said you don't have to. Even if you say, okay, maybe corporations can be PACs, maybe they can't. I don't think they can. But wholly apart from that, this commission told my client he didn't have to file a statement. And that clearly is what this case is about, that we should be subject to a hearing and evidentiary procedures because we did exactly what this commission told us we had a right to do.
Mr. Richter, will you walk me specifically, but perhaps us, through the advisory opinion that we've heard so much about today? I have it here on my computer. Dated September 2, 2010. Obviously, I'm aware through our sheet what your recommendation is. I would like to hear from you as to why your recommendation is that, and I'm assuming that it is built up on the advisory opinion from 2010.
I think primarily, yes.
Okay.
And that opinion, again, came as a result of the Supreme Court's decision that is certainly been talked about here at Citizens United, which essentially said corporations have a right to use their funds for endorsement whatever, as it relates to individual candidates, which was a prohibition that was in federal law. It was a prohibition in Ohio law. And while those respective prohibitions were not exactly the same, they were incredibly similar when that law was handed down. And at least my understanding at the time, I don't think it's changed, is that when the Citizens United decision was handed down, it essentially, again, allowed corporations to involve themselves in candidate campaign committees. Wherein they were previously prohibited from doing so. And so the opinion that the commission approved at that point essentially said, we will follow along with what the US Supreme Court said in the Citizens United decision. And we will not apply the prohibitions of 359903 against a corporation that involves itself in a candidate campaign committee, regardless of how they involve themselves in a candidate campaign committee. And that's the essential decision of this commission, based on what the US Supreme Court said in Citizens United. I respect both these gentlemen greatly in their respective arguments. I appreciate what Mr. McTighe, where he's coming from as it relates to there's that doesn't mean that they can't be a PAC. I would disagree with that because this is a corporation, a 1701 type of corporation that would normally be that would have previously been subject to 359903 and prevented from involving itself in individual candidate campaigns. But by the decision of Citizens United, that this commission essentially endorsed in its opinion. You've said that corporations have an ability to involve themselves in individual candidate campaigns, and that they are not subject to the penalty provisions of 359903. I don't believe that a corporation could be. You presumably, if you wanted to, because just about anybody that want to could be a PAC. I mean, it says 2 or more persons, but if you or I decide to go out and file a designation of treasurer just as ourselves, we're a PAC under Ohio law. That's the way Ohio law reads. And I appreciate the definition of Ohio law. But as I view this, when Worthington was a 1701 type of corporation that established themselves as such, with all due respect to their 501c type of standing, while certainly that could have a marginal interest or impact in what's going on here. That's an IRS designation. That doesn't have anything to do with Ohio law establishing a corporation. And so that's essentially where I'm coming from. And that's, I would say that's essentially where I have consistently come from. Anytime we get a complaint, I can't say we've had a lot of complaints like this over the years, but I get an allegation that is presented to the commission that says, this is a corporation that's acting improperly. I look to this opinion and say, no, I don't believe that to be the case. You have said that a corporation can act in this manner and can involve themselves in political activity by essentially the whole of the Citizens United that we have, that this commission has endorsed through its advisory.
And so I'll follow up on that. I'm very close to agreeing with your recommendation, Mr. Richter, but the problem, if I can think out loud for a moment. When we talk about a corporation, let's just say it's a Ford Motor Company who wants to influence an election, whatever the case. The Ford Motor Company as a corporation doesn't seek contributions from the general public. So I have to say that to get there, get where I'm going. This is the concerning part for me. If you're a corporation, by knowledge, you don't ask other people for money. It's the corporation's money, right? So on the website, the one where they give us, I mean, there are clearly donate tabs, et cetera. How would you make that separation mentally? Because I'm trying to do that. Because it looks a heck of a lot like advocacy to me, regardless of how much they're spending with social welfare versus political activity, but the contribution part is troublesome for me. So to the extent in which you can, would you expand upon that part of it?
I'll go back and, to me at least, make it much more simple, is that when a corporation establishes itself, either under 17 or under 17 as a corporation, that puts you within the parameters of not only the statute, but the commission's opinion. And while you're talking about donations and the solicitation thereof, I mean, if you look at, you mentioned before, but it doesn't matter, almost any other type of corporation, they're selling shares. They're getting funds in from, other persons to establish and to further their organization. And it's not contributions as we're seeing here, but it's buying stock or doing whatever else that you do to participate in that corporation. I don't know that from a personal standpoint, I don't know that I like either the opinion or what the statutes say. And I think that the General Assembly, in my opinion, the General Assembly should have done more to go out and as a result of Citizens United and do further things to capture some of the activities that have gone on here. But again, I have to agree with Mr. Rye. And while it's not doing it in this particular case, in other circumstances, Mr. McTighe has made those kind of arguments where that's the General Assembly's responsibility, is to enact laws and put laws in place. This commission is responsible for enforcing them. And so the General Assembly never moved forward any further to take this opinion and say, no, we want to do it differently, or we want to expand. Here's filing obligations under 3517-105. None of that has been done. And again, whether it's seeking contributions as you see here, or whether it's creating a corporation and then going out and, you or I could go out and create a corporation. And then if the corporation's doing that, I've got to put money into it if I create a corporation, or I have to buy shares, or you can solicit on a broad basis persons to buy shares of the corporation. To me, it's when you file and you create yourself under either 1701 or 1702, you put yourself in a situation where you have an ability to rely. To me, you have an ability to rely on the commission's advisory opinion that says, as a corporation, I can involve myself in candidate political activity now based on what the decision of the Supreme Court, and you have an ability to go forward.
We can just have a seat for just a moment, because I think we'd like to kind of, there's some things that other commissioners wanted to, just based on that, that's.
Okay, I just had a cite to the administrative code.
I'm sorry?
I just was going to cite to the administrative code that said 2 more people do not include contributors.
Okay, thank you.
Okay, Madam Chair, thank you. My concern, so I'm still looking, this goes back to Stephen's question too. But when I look at the decision and I look at our synopsis, all right, and I look at their website, the synopsis says, excuse me, Ohio Elections Commission will interpret and apply Ohio Revised Code, 17-105 and 103 in light of the United States Supreme Court decision in Citizens United. And thus a corporation will be permitted to independently participate in partisan political activities. Now, underscore this in my mind, as long as such participation is independent of and not coordinated with any candidate or political party, the corporation will not be subject to find a violation by the commission. I go back to the website where it says, it has a list of what they're doing politically, and then it says finding new candidates. And I believe that's enough probable cause, because I do not know Are you finding candidates without talking to them or quote coordinating with them? And that's what our opinion says, that we cannot coordinate with people. So I'm of the mind, I know you're gonna have more questions, but quite frankly, I'm of the mind of taking it to hearing based on our own website and one Worthing website.
And I have a comment and question. So first, all due respect, the executive director, when you invest in a corporation, use Ford as an example, you invest because you believe in the business prospects and, you know, the return that you would get on investment. It is a investment and business decision as to why if you were to go and put money into the Ford Motor Corporation, and then they were to direct 90% of their capital to political activity, you would have no result, right? It's apples and oranges. It just is. Here you're asking for donations for political purposes. That's, at least on the website, the clear reason. It's totally different. My question for the executive director is, so let's say that me, Commissioner Hagan and Commissioner Lyle go out to the website with the Secretary of State, form a corporation, which takes about 10 minutes to go through that. And now we have a corporation, we have a filed corporation, and then all we do is find a candidate of choice and advocate and do the whole 9 yards. Are we not effective?
I don't believe so, no.
But that would go very much against what the Ohio Revised Code says, right? It's because that's all we're doing, just because we filed the corporation forms, which take 10 minutes to do. I mean, they don't ask hardly anything.
Don't disagree, but once you create that corporation is a single entity. It is not, I mean, I appreciate that the three of you, or if it was you and I for that matter, getting together, you are creating a single entity. That corporation is an entity. It is not multiple. To me, at least, it doesn't meet the definition of two or more persons, because the corporation itself is an entity. It is a person, and that's all it is.
And even if our full intent, and that you would admit this, full intent is to avoid laws around tax, whatever they are, disclosure, whatever they are, but that's the whole intent, then the view of this commission should be that is okay.
It's making a big assumption and a jump to say that that's the sole reason why.
But I'm saying it could be, it absolutely could be. Let's say that was what we were doing, literally. This is a hypothetical. Literally, we want to avoid all the disclosure rules of PACs or whatever about PACs we don't like. So we're going to incorporate to avoid them. That is what we're doing.
And
that's,
that is a policy decision that the General Assembly has made by not changing the statute any further to capture those kind of circumstances and bring that kind of activity, into a situation where it would potentially be a violation of the statute.
and how do we know that the way they wrote the statute was not meant to incorporate that by requiring us to be a PAC? Because that's how I would read the statute. I mean, to me, that was the policy decision if you take the literal wording of it. So
You need two or more persons.
the two or more persons with respect to advocacy, I read that as encompassing the policy right there.
First off, that definition, I don't know exactly when that definition specifically was brought into play,
Doesn't matter.
but it was done well prior to the whole Citizens United, when corporations weren't allowed to involve themselves in individual candidate campaigns. That was at a time prior to that. It was created back then. That's part of the reason why the other advisory opinion that was referenced that said, no, it only applies to 1701, 1702 type of corporations. That statute was, I think, originally created in the 50s or 60s when that's the only type of corporation that we have. And over the years, there were various other types of entities that were brought into being, but the General Assembly never expanded the definition of 359903 to capture anything else. So, you know, you look at when, at least to me, you look at when the statute was originally enacted, what it applied to at that time, and at the time when it was originally enacted, two or more persons literally meant two or more persons. At least you and I, you and Mr. Lyle and Ms. Hagan, going out and creating something that's totally separate, distinct from a corporate, you know, you guys then creating a corporate entity. You know, that wasn't the application at the time. You know, so I mean, that's part of the way I look at it.
What is the sticking point with Commissioner Lyle and Commissioner Knight? If I'm understanding what you're saying, and maybe even you, Mr. Caraway, it says, as long as there is no direct contribution to or coordination, is the coordination with either candidate's campaign committee or partisan? I mean, is that really where it's, you think they're kind of coordinating with them or trying to,
I'm, you know, based on their website, I don't know how you find new candidates. There's a list of things they do.
right.
The last one says, and find new candidates. Now, I've done as much politics as anybody in this room. I don't know how you find the candidate without talking with them directly.
Right.
Right?
That's
So there has to be a coordination in order to do what they're saying they're doing. And then based on our own summary that Phil has here, it says, and not coordinated with any candidate or political party. So, and I'm again using the probable cause standard, which is minimal, but you know, is there probable cause? Yeah, I think we need to investigate. It's my own personal, just based on that and based on everything I've heard today.
So it's not so much the fact that it's two or more people, it's just what the corporation is participating in.
If I look at this, all the evidence presented in my mind, they're functioning as a PAC. And they're not reporting.
And my sticking point is the same. All the evidence would tell me they're operating as a PAC. And there's been a lot of discussion today about reliance on an advisory opinion.
Right.
So I would take the opposite view of that the people of the state of Ohio rely on the Ohio Revised Code, right, for us to monitor and enforce the Ohio Revised Code, which expressly is stated there, right?
Right.
So all due respect, I think that trumps an advisory opinion, right? And I'm not, from what I've read of the advisory opinion and what I've heard, I don't think it covers this situation specifically, where based on the evidence, just looking at the website, I mean, if it walks like a PAC and it talks like a PAC and it looks like a PAC, the only thing about that's not a PAC is they chose to file paperwork that made them a corporation, which I'm telling you, I do it all the time, is not a high bar. It is easy to do. We can find one and get one set up in about 15 minutes if we want to. So that's my, where my thought process is.
And I guess I would have to comment on this as well. I would agree with Mr. Knight. You know, we can't assume one way or the other how the legislature feels about Citizen United and the advisory opinion that was issued. Simply because they haven't taken any action doesn't mean that they support A or B. They haven't taken any action. We can't assume one way or the other what their opinion. They may not have even paid any attention, particularly this many years later. I mean, if they wanted to do A, they could have taken action. If they wanted to do B, they could have taken action, and they haven't. I agree with Mr. Knight. It seems as though everything that they're doing is what a PAC will do.
One other point I will make to your point, you may disagree with this, and I respect and understand that, but to me, they're going out and seeking candidates. Doesn't necessarily fit within the definition of a PAC to me. Because what this says is to support or oppose any candidate, political party issue, or to influence the result of any election through express advocacy. Just merely going out and trying to get someone to be a candidate, when you're reaching out to them, they're not a candidate.
So they're paying their website, Phil. It's a slate.
No, I understand. But they're reaching out to try and get a candidate to submit petitions to become a candidate. To me, I view that as being different, and I respect that you're certainly welcome to disagree with my take on that. But going out and saying, okay, I'm going out to get candidates. I mean, you could go out, you said you've been, I think everybody thinks, I mean, you go out and you talk to Joe and you say, Joe, I want you to be a candidate, you're seeking a candidate, and Joe says, there's no chance in anything to be going to do that because I'm not going to do it. He might also say, yeah, okay, I will. At that point, then he's got to go out, circulate petitions, get his name put on the ballot. There's a difference between merely going out and seeking that as opposed to supporting or opposing the candidate as is included in the definition here.
I appreciate that. I don't necessarily agree with it, but I appreciate it.
I didn't think you would.
Duly noted.
Is there a motion?
May I make a comment first?
No.
Okay,
It's something that came up only during discussion.
Madam Chair, I would just,
I was
due respect to Mr. Bryan, this is not a hearing. And it's getting to the point where it's like a hearing.
Well-
I mean, this is our time to discuss. And once we discuss, we have a right to make a motion.
right.
The memorandum in opposition said that it does not.
Sides that kind of express, and
Mr. Lyle has injected a new issue that was not in the complaint. And it says so right in the memorandum in opposition. He said that this matter does not allege that respondents unlawfully coordinated with any particular candidate. And therefore it would be improper. We had no notice that was going to be something argued. If Mr. Lyle wishes to make an affidavit complaint about that, he can, but it would not be a proper basis for this commission to vote.
allowed. Notice, maybe,
Well,
I would like for you to have the opportunity to respond.
well, just again, the fundamental issue is, whether they meet the statutory definition of a PAC. Whether we're talking about whether seeking candidates is PAC activity or not PAC activity. There's certainly plenty of other activity that went on here, yard signs, door hangers, etc., that could be very, very easily construed as PAC activity. So the question is, do they meet the statutory definition of a PAC? Mr. Richter, I actually agree with his summation earlier on Citizens United, but then Mr. Richter informing his opinion from there, because he correctly stated that that was about whether a corporate prohibition could be enforced on using corporate money. That's what the case was. But then his opinion that he's expressed beyond that is that the jumping off point is, okay, corporations can spend money and therefore for some reason he concludes that they can't be a PAC, but that was not the issue in that case. And that's the issue before you. Thank you.
So, having heard both sides presentations, we've heard Mr. Richter's opinion, we have an opinion in front of us. Are there any further questions or discussion?
All right, let me just say this based on what Mr. Bride said, and I'll stop. I will not take into consideration, since that was not in the complaint. I understand what he's saying. So when I make my decision, I'm not gonna base it on coordination, but I will base it on the other evidence. Just wanted that for the record. Okay?
I move that we deny the motion to dismiss and set the matter for hearing.
Second. We have a motion on the floor that's been duly seconded. I feel maybe a roll call.
I think that would be appropriate. Mr. Lyle,
You know, I want to be clear on the motion.
motion to deny Mr. Bry's motion to dismiss, which is the first one before us, and then to set the matter for hearing.
Moving the hearing, yes.
Ms. Hagan. Mr. Caraway,
Aye.
Mr. Knight,
Aye.
Mr. Polkie, Ms. Tavares,
Aye.
Ms. Kaufman.
No.
That motion passes 6-1.
Thank you, gentlemen.
Thank you.
Okay, what else do we have?
That's it. The next meeting being October 12th.
The next meeting of the Ohio Elections Commission is October 12th, 2023.
I can, could we get a date for reconvening, Mr. Hicks?
No later than October 26th. I'll be reaching out to you all later on today.
Any updates on size of elections?
No, I should, I'll reach out.
Yes.
Yes,
Yeah.
okay.
No, we're not dismissed.
No,
I'll move to adjourn.
Hold on, Commissioner, I'm sorry. Yeah, you actually had a very good point. They both over here at all in. On the agenda,
Oh, there's another case on the agenda, but we did not address it because it involves the first case.
okay,
If the parties had appeared, and I should have commented on that, if the parties had appeared, then I was gonna be prepared to go forward and make a recommendation. When they didn't
You thought I was
appear-
crazy, didn't you?
Yeah.
no, it was.
No, that, when notices were sent, they were sent for the next meeting,
Okay, okay.
but I was hoping that the parties would appear and then we can get rid of it. Because you can see the recommendation that I put there, it's very, it would be the same coming into the next meeting, but when they didn't appear, we can't go forward at this point because we noticed them for the next meeting, and I should comment about
See, I knew that. I was well aware.
There.
it. And I should,
My apologies.
that's why it's not on there.
Thanks, Chris.
The other comment I'll make, if I may, Madam Chair, is this was really the first long preliminary review that I been part of as commissioner, and it is incredibly difficult to ask questions because there's a bunch of teeter totter, right? So you're asking a question and then, you know, you ask it and then there's a response. And then I tried to narrow because I thought that point was over and I wanted to narrow my discussion with you. Are there parameters that, I mean, obviously when I ask a question, everyone gets to respond, but is there a time limit or?
We have at times set them,
Okay.
but generally we don't. This is
And I'm
more
not
of a rarity,
Today was.
you know.
It was distracting.
It was.
It was extremely distracting. I felt it was rude. But I have a hard time telling people, sit down, you're being rude. I have a hard time.
I
know.
I don't. I'll do it.
It's all they want, so that's right.
I mean,
I know you're this one.
I don't, maybe I'm too, you know, but I guess too, in the years that we've been here, we really have never said, sit down, you can't speak anymore. It's been very rare. So I guess I'm going on precedent of what we've done in the past to allow people to, you know, because points have been brought up. And I do feel it was, within, you know, Mr. Bryce, you know, parameters to say, listen, that's not what's on the table.
Right, and that's
Yeah,
why,
so I-
I said I was.
Yeah,
not
and
gonna
and
make
I
my
respect that
decision
you're
based
very
on that.
gracious about
Yeah,
that.
well,
But, I mean, I do believe that that probably is a point that he needed to make and we probably needed to hear.
The only question I would have on that is, we should probably let the complainant and respondent know, we've concluded the preliminary.
Right.
And I should have mentioned
Yes, and now we should have our discussion, because for them to comment, and I know in this case, you know, it was probably helpful, but for them to comment on our comments is not appropriate.
I agree.
It may be you saying, if you'd like to say, should the commission members have any additional questions, you're welcome to do
Right.
that. And then that way it's
Exactly.
to their benefit to stick around, but they're not chiming.
Well, they have to be here, right? For us to have the discussion, we can't have it without them kind of.
Well, I mean,
It's an open sunshine law.
yeah.
doesn't mean that.
They can leave, but they're not going to.
So just going forward, I will say, have you rested your comments? Do you feel like you made all your points? Because at this point, you're no longer able to contribute once we start our discussion. So that's not with that.
Yeah.
You know,
Here, please do not take my comment as, I wasn't being critical of Lady Running Green, at all. I was like.
No, it's totally fine. It was
I saw
distracting.
Questions.
I know, and I apologize that it's not.
It's not an apology. I think it's just,
I would,
we're wondering what the farm is all around.
yeah,
It's not.
actually, one of my recommendations is going to be kind of reviewing as a group the rules of the forum. Because if we were in a courtroom, the judge would have like stopped them, so, because most of it was repetitive.
It was.
This over and over and over, and the judge would have stepped in, you've already went there, either move on or, I mean, they wouldn't let them just throw on and on and on about the same things. Every reply
Yeah.
was pretty much a repetition of something that folks are, which was all a repetition of the complaint response.
Well, let me apologize to all of you because I complimented them.
yeah.
They decided they wanted to play along. So
I actually enjoyed listening to them
Yeah.
go back and forth.
I did for a while, but then I was like, no, you're not, you're telling the same things. I so much wanted them to.
Like a 5 hour.
Of course, I kept this out.
Yeah, it was 25 back and forth. Even when you throw your gavel down, you won't have to do it frequently.
No, I
That
think
is just like
it's
rear and shoulder, you know,
Yeah.
once they know that that's your tone, they won't want to be embarrassed right now.
I do think
I
that's.
think that they know they can push me around.
Well, no, they know your choices.
The precedent has been set that we pretty much let people say whatever they want to say. And push forward to the, yeah,
It's
and.
an informal.
It's not just something that's approachable.
It's not like we are in the courtroom.
So, you know, you're doing what all the peers have done. I
But
just
that's
think
true
we
because it went to a point where 23, 24, letters like you.
I think we can revisit
And
our
you just have your
rules of it.
threshold and then.
I think that was yesterday.
Here and there.
I heard Mayor yesterday. Watch.
Yeah, that's, today was more just the repetitiveness, right, the tennis back and forth.
No, but I mean, I am open and I accept anything you say. And if there's something I can do differently, I will absolutely set that, you know, to set the bar to say, you close anything going forward. You really can't comment because this is our discussion time. This is, it's not review interrupted at this point.
Yeah, but you're doing a good job.
Yeah.
And yesterday, I would note, yesterday was much more respectful in tone than it has consistently been. So I think even just saying out loud, this is the way forward.
Yeah.
You're in good shape. So you're on your way. You're just saying, you're, what, by the time it is
Christmas party now anyway.
Oh, yeah, that's true. Yeah, we're over that threshold.
Yeah, we saw what year 5 of auto. I mean, come on. It's like-
Yeah, so
I'll move to adjourn.
I'll second.
we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carried with a vote of 7-0. Meeting is adjourned as of 12:46.
Thank you very much. Thank you for spoiling.
Yes, on my way up here, I was going to hear, I said, oh, I'll be back to the office by noon.